Owen Calloway had not spoken to his brother in 14 months when the letter arrived from the solicitor. He almost did not open it. He assumed it was another piece of the estate administration that James had already handled, something routine that required his signature on a form he had never read. That was how it had always worked between them after their father died. James managed everything. Owen trusted him completely. He had been trusting James his entire life. Their father, Robert Calloway, had died 3 years earlier at 71. A quiet man who had spent 40 years building a small but successful surveying firm, and who had, over the course of his life, managed to purchase and pay off a substantial family home in Surrey, a 4-bedroom Victorian property on 2 acres that had been in the family for over 2 decades. In his will, Robert had left everything equally to his 2 sons. The firm was to be sold and the proceeds split. The house was to be sold and the proceeds split. James, as the older brother and the one who had always been closer to their father, was named executor of the estate. Owen had no objection to any of it. He lived in Edinburgh, worked in architecture, and had a life that was full and separate from the one he had grown up in. He trusted James to handle it cleanly. He told him so at the funeral, standing in the rain outside the church, and James had squeezed his shoulder and said he would take care of everything. The firm sold within 4 months. Owen received his half of the proceeds without issue, £230,000, transferred cleanly to his account, with a brief email from James confirming the completion. The house was a different matter. James explained that the property market in Surrey was slow, that they would get a better price if they waited, that he was managing viewings and would update Owen when there was serious interest. Owen accepted this without question. He had no reason not to. A year passed, then another. Each time Owen asked, James had a reason: a difficult buyer who had pulled out, a survey that had flagged something requiring attention, a market that was not moving the way they had hoped. Owen grew frustrated but never suspicious. James was meticulous. He had always been meticulous. That was simply who he was. The letter from the solicitor arrived on a Thursday morning in November. It was not from James's solicitor. It was from a firm Owen had never heard of based in Guildford, writing to inform him that the property at Ashford Lane, Surrey, his father's house, the house he had grown up in, had been sold 18 months earlier. The sale had completed in April of the previous year. The full proceeds had been transferred to a single account. Owen's name was not on it. He read the letter 3 times sitting at his kitchen table in Edinburgh, the coffee going cold beside him, trying to find the part where it made sense. There was no such part. He called James that evening. James did not answer. He called again the following morning. James picked up on the 4th ring, sounded surprised to hear from him, asked how Edinburgh was. Owen told him about the letter. There was a pause on the line that lasted long enough to confirm everything Owen had spent the previous 24 hours refusing to believe. Then James said there had been a complication with the paperwork, that Owen's share had been set aside in a separate account while they sorted out a tax matter, that he had been meaning to call, that everything was fine. Owen said nothing for a moment. Then he said he understood, thanked James for explaining, and ended the call. He sat very still for a long time after that. Owen was not a confrontational person. he had never been. Growing up, it had always been James who argued, James who pushed back, James who made his position known. Owen had learned early that the quieter path was usually the more effective one. He applied that instinct now. Instead of calling James again, he called a solicitor. Not the family solicitor who had handled the estate, a different one recommended by a colleague, someone with no prior connection to the Calloway family. He explained what he knew. He sent the letter. He asked what his options were. The solicitor called back 2 days later and told Owen that what he was describing, if accurate, constituted fraud. The investigation took 11 weeks. Owen's solicitor requested the full land registry records for the property. They showed that the house had been transferred out of the estate and into James's sole name 7 months before the sale, using a deed of variation, a legal document that, if properly executed with both beneficiaries' consent, allows an estate to be redistributed after death. If improperly executed, it is forgery. Owen had never signed any deed of variation. He had never been sent one. He had never been asked. The signature on the document bore his name. It was not his handwriting. A forensic document examiner confirmed this in a written report that Owen's solicitor received on a Wednesday afternoon in February, 14 months after their father had died, and 11 months after the house had been quietly sold. The net value of Owen's stolen share was £412,000. During those 11 weeks, Owen did not contact James once. He did not reply to the 2 messages James sent asking if everything was all right. He did not respond to the Christmas card that arrived in December with a handwritten note inside saying they should get together in the new year. He went to work, he came home, he spoke to his solicitor. He read every document he was sent with the same careful attention he gave to architectural plans, looking for the load-bearing details, the things that held everything else up. He was building something not quickly, not loudly, just steadily, the way he did everything. In March, Owen's solicitor sent a formal letter to James outlining the findings, the forensic report, and Owen's position. The letter gave James 14 days to respond. James responded in 4. His own solicitor wrote back acknowledging that there had been an administrative error in the estate process, that James had intended to resolve the matter before Owen became aware of it, and that James was prepared to discuss a settlement. Owen's solicitor called Owen after receiving the letter and read him the relevant section. There was a silence on the line. Then Owen asked what his solicitor recommended. His solicitor said they could settle privately, which would be faster and less expensive, or they could proceed to litigation, which would be slower, more expensive, and significantly more public. Owen asked what significantly more public meant in practice. His solicitor told him. Owen said he would think about it overnight. He called back the following morning and said he wanted to proceed. Not because he needed the money, though £412,000 was not nothing. Not even primarily because of the fraud, though it was that. It was because of the signature. James had not made an administrative error. James had forged his name on a legal document to steal their dead father's house from him, while Owen was grieving and trusting and 300 miles away in Edinburgh. James had then spent 18 months lying to his face about it, inventing stories about slow markets and difficult buyers and tax complications, while the money sat in an account with only his name on it. Owen wanted that on record. He wanted it stated clearly in a public forum, in language that could not be softened or spun. He wanted the facts to exist somewhere permanent. He told his solicitor to proceed. The case was heard in the county court in London 6 months later. James arrived with a barrister and a revised account of events, one in which the deed of variation had been a genuine misunderstanding, in which he had believed Owen had given verbal consent during a phone call, in which the money had always been intended to be shared and had simply been held pending resolution of a related tax matter. The forensic document examiner gave evidence. The land registry records were presented. The timeline of James's messages to Owen during the 18 months in question, cheerful, routine, entirely unrelated to the property, was submitted as evidence of deliberate concealment. James's barrister was thorough. James himself was composed. He answered questions carefully, gave nothing away, looked at Owen directly when he spoke. Owen sat on the other side of the courtroom and listened to all of it without expression. The judge found in Owen's favor on all grounds. The deed of variation was ruled fraudulent. The transfer of the property into James's sole name was declared void. James was ordered to repay Owen £412,000, plus interest, plus Owen's legal costs, within 90 days. The judgment was recorded in the public register of court decisions, where it would remain indefinitely. The judge described James's conduct as a deliberate and premeditated breach of his duties as executor, undertaken at a time when his brother was grieving and had placed significant trust in him. James sat very still when the judgment was read. His barrister made a note. Neither of them said anything. Owen thanked his solicitor outside the court, shook his hand, and walked to the car park alone. James paid within the 90 days. The full amount, plus interest, plus costs, transferred in a single payment without further communication. Owen did not acknowledge it beyond a formal confirmation from his solicitor. He did not call James. He did not write. There was nothing he wanted to say that had not already been said more precisely and permanently by a judge in a London courtroom. Their mother had died when they were children. They had no other family to speak of. The Calloway brothers had been, for most of their lives, each other's closest connection to the people and the house they had grown up in. That was over now, cleanly and completely, in a way that required no further conversation from either of them. Owen used part of the money to buy a flat in Edinburgh outright. He used another portion to set up a small trust in his father's name that funds a bursary at the school Robert Calloway had attended as a boy in Surrey. He chose not to think too carefully about the symmetry of that. The money James had taken from their father's estate returned to the world in their father's name. He thought about it anyway sometimes, on the train to work in the morning, and found that it was one of the few things in the whole affair that made him feel something close to settled. James Calloway's name appears in the public register of court judgments. It will remain there. Owen does not know whether James thinks about that. He does not particularly need to know. Some betrayals are committed by strangers. Some are committed by people who sat across from you at your father's funeral and told you they would take care of everything. The second kind leave a different kind of mark. Not louder, just longer. If you made it to the end of this story, you already know why these stories stay with you. Every week, a new one. Subscribe so you never miss it. The next story involves a woman who built a company over 12 years, only to discover the person she trusted most had been preparing to take it from her the entire time. It is, in its own way, even colder than this one,